Okay, good morning, everyone.
Good morning.
Good morning.
I am Clarissa Rodriguez, Chair of the New York State Workers Compensation Board, and I now call to order the 980th meeting of the board. Welcome, everyone. Madam Secretary, will you please call attendance?
Yes, Vice Chair Foster.
Here.
Board Member Pevrocky.
Here.
Board Member Higgins.
Here.
Board Member Lovett. Board Member Williams.
Here.
Board Member Hall.
Here.
Board Member Osley.
Here.
Board Member Crane.
Here.
Board Member Stasko.
Here.
Board Member Tavares.
Here.
Board Member Cajanelli.
Here.
Board Member Delon.
Here.
All members are present.
Thank you, Madam Secretary. Agenda item 1, approval of the July 2019 meeting minutes. You have all received a copy of the minutes to review. Are there any questions or need for discussion?
Move to approve.
Thank you.
Second.
Okay, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Agenda item 2, Office of General Counsel's Departmental Report. General Counsel David Wertheim will present the statistical and informational report for July and August.
Thank you. Good morning, Chair, Vice Chair,
Good morning.
board members, comrades.
Good morning.
Here is a statistical report for July and August 2019 in the 3 areas of issue resolution at the board. First, in the adjudication division in July, 17,686 hearings were held, 11,201 cases fully resolved at the hearing, with 464 reserved decisions being issued. In terms of waiver agreements, there were 2,214 approved waiver agreements, 1,691 by hearing, and 523 by desk decision. In August, there were 18,056 hearings held, 11,475 cases fully resolved at hearing, and 479 reserved decisions issued by workers' comp law judges. Waiver agreements, 2,149 completely approved, 1,630 by hearing, and 519 by desk processing. In terms of memoranda of decisions through the Administrative Review Division, in July, there were 1,118 applications received, 1,164 applications processed, and in August, there were 1,028 applications received, 1,245 applications processed, leaving inventory at end of August at 2,570, with 96% of all review applications fully resolved within 6 months. In terms of full board review, in July, there were 185 applications received, 210 processed, and in August, 153 applications received, 203 processed, leaving a full board review case inventory at the end of August of 266. That concludes the report of Office of General Counsel. Of course, I would take any questions. Thank you.
Okay, are there any questions or need for discussion?
Move to accept the report,
Thank you. All in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Licensing applications. Elizabeth Lott of the Office of General Counsel will now present any licensing applications.
Good morning, Chair, Vice Chair, board members, colleagues. You have before you the recommendation from the assigned board panel regarding licensing applications listed in Part 3 of today's agenda. Under Section 24A, there is nothing to consider. Section 53B, Standard Life Insurance Company of New York, 3-year renewal. Claims Service Bureau of New York, 3-year renewal. Under Section 53D, Creative Risk Solutions LLC, 1-year renewal, and Emerald Claims Management of New York LLC, 1-year renewal. I present these recommendations to the board for your consideration.
Okay. Are there any questions or need for discussion? May I have a motion to accept?
Move to accept.
Thank you. Okay, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Agenda item 4, legal appeals. General Counsel David Wertheim will now present the recommendations concerning decisions by the Appellate Division.
Thank you again, Chair. From the time of the July board meeting, the Appellate Division 3rd Department issued 22 decisions with respect to workers' compensation claims. In all 22 of those cases, the board's decision was affirmed. It's the recommendation of Office of General Counsel that all of the decisions of the court be adopted as decisions of the board.
Okay. Is there Any need for questions or need for discussion? Okay, may I have a motion to accept the recommendation?
Motion to accept.
Okay, second. All in favor?
Aye.
All opposed? I am also a yes. Thank you. Agenda item 5, mandatory full board review. 5A, Brickworks Construction Incorporated, case number G1397289. Is there a motion with respect to 5A on the agenda?
Yes, Madam Chair, I move that the dissenting opinion be adopted as the opinion of the full board.
Is there a second?
Second.
Okay. Are there any recusals in this matter? Is there any opposition to the motion?
Yes.
Okay. Seeing there is opposition, I'll ask the secretary for a roll call vote.
Board Member Osling.
Yes.
Board Member Logan.
No.
Board Member Higgins.
No.
Board Member Hall.
Yes.
Board Member Delon.
Yes.
Board Member Williams.
No.
Board Member Gajanelli.
Yes.
Board Member Crane.
No.
Board Member Petracki.
Yes.
Board Member Taveras.
Yes.
Board Member Stasko.
Yes.
Vice Chair Foster.
Yes.
Chairwoman,
Yes.
that motion is passed 9-4.
Okay, thank you. 5B, Sportsman Alamo, case number G0550203. Is there a motion with respect to 5B on the agenda?
Yes, Madam Chair, I would move that the majority opinion be adopted as the opinion of the full board.
Okay, is there a second? Thank you. Are there any recusals in this matter? Is there any opposition to the motion?
Yes.
Okay, in light of the opposition, I call upon the secretary for a roll call vote.
Board Member Hall.
Yes.
Board Member Taveras.
No.
Board Member Stasko.
Yes.
Board Member Crane.
No.
Board Member Osling.
Yes.
Board Member Delon.
Yes.
Board Member Logan.
No.
Board Member Higgins.
No.
Board Member Petracki.
Yes.
Board Member Williams.
No.
Board Member Cajanelli.
Yes.
Vice Chair Foster.
No.
Chairwoman.
Yes.
That motion is carried 7-6.
Okay, thank you. 5C, New York and Presbyterian Hospital. Case number G2261897. Is there a motion with respect to 5C on the agenda?
Yes, Madam Chair, I would move that the majority opinion be adopted as the opinion of the full board.
Thank you. Is there a second? Thank you. Are there any recusals in this matter?
I'd like to recuse myself from this case.
Okay, duly noted. Is there any opposition to the motion?
Yes. Yes.
Okay. In light of the opposition, I call upon the secretary for a roll call vote.
Board Member Cajanelli.
Yes.
Board Member Hall.
Yes.
Board Member Petracki.
Yes.
Board Member Osling.
Yes.
Board Member Logan.
No.
Board Member Higgins.
No.
Board Member Stasko.
Yes.
Board Member Delon.
No.
Board Member Williams.
No.
Board Member Crane.
No.
Vice Chair Foster.
Yes.
Chairwoman.
Yes.
That motion is carried 7-5.
Okay, thank you. 5D, Iberia Food, case number G1656217. Is there a motion with respect to 5D on the agenda?
Yes, Madam Chair, I would move that the case be removed and denied for review based on June 2023.
Okay. Are there any recusals? Is there a second? Sorry.
Second.
Okay. Are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. 5E, Nicholson E.E. Cruz. Case number G0107045. Is there a motion with respect to 5E on the agenda?
Yes, Madam Chair, I move that the majority opinion be adopted as the opinion of the full board.
Is there a second?
Second.
Okay, are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. 5F, Scalzo Utilities, case number G2142050. Is there a motion with respect to 5F on the agenda?
Yes, Madam Chair, I move that the majority opinion be adopted as the opinion of the full board.
Is there a second?
Second.
Are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. 5G, Suffolk County Sheriff's Office, case number G1537480. Is there a motion with respect to 5G on the agenda?
Yes, Madam Chair, I would move that the dissenting opinion be adopted as the opinion of the full board.
Is there a second? Thank you. Are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. 5H, Lowe's, case number G0454667. Is there a motion with respect to 5H on the agenda?
Yes, Madam Chair, I move that the majority opinion be adopted as the opinion of the full board.
Is there a second?
Second.
Okay, are there any recusals? Is there any opposition to the motion?
Yes.
Okay, in light of the opposition, I call upon the secretary for a roll call vote.
Board Member Crane.
No.
Board Member Delan.
Yes.
Board Member Williams.
No.
Board Member Ostley.
Yes.
Board Member Stasko.
Yes.
Board Member Higgins.
No.
Board Member Hall.
Yes.
Board Member Logan.
No.
Board Member Taveras.
No.
Board Member Paprocki.
Yes.
Board Member Casamani.
Yes.
Vice Chair Foster.
Yes.
Chairwoman.
Yes.
That motion is carried 8-5.
Okay, thank you. 5I, Starwood Hotels and Resorts, case number G0651200. Is there a motion with respect to 5I on the agenda?
Yes, Madam Chair, I move that the board panel decision be adopted as the opinion of the full board.
Okay, thank you. Are there any recusals in this matter? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. And finally, 5J, New York City Transit Authority, case number G1398833. Is there a motion with respect to 5J on the agenda?
Yes, Madam Chair, I move that the majority opinion be adopted as the opinion of the full board.
Thank you. Is there a second?
Second.
Are there any recusals in this matter? Is there any opposition to the motion?
Yes.
Okay. In light of the opposition, I call upon the secretary for a roll call vote.
Board Member Williams.
Yes.
Board Member Stasko.
Yes.
Board Member Logan.
Yes.
Board Member Higgins.
Yes.
Board Member Taveras.
Yes.
Board Member Ostley.
No.
Board Member Casanelli.
Yes.
Board Member Hall.
Yes.
Board Member Delan.
Yes.
Board Member Paprocki.
Yes.
Board Member Crane.
Yes.
Vice Chair Foster.
Yes.
Chair.
Yes.
That motion is passed 12-1.
Okay, thank you. Agenda item 6, discretionary full board review. I turn this portion of the agenda over to Vice Chair Foster.
Thank you, Madam Chair. For the cases listed on item 6 of your agenda, it is recommended that full board review be granted. Those cases are 6A, matter of Rochester General Hospital, 6B, matter of Mount Sinai Medical Center, and 6C, matter of SKF USA, Inc. I move to refer the cases back to the respective panels for further consideration.
Okay, is there a second?
Second.
Thank you. Are there any recusals in either of these matters? Is there any opposition to the motion? Okay, seeing no opposition, all in favor?
Aye.
All opposed? I am also a yes, that motion is passed. Thank you. Agenda item 7, other business. Seeing there is no other business, agenda item 8, our guest speaker. Today, our departmental guest speaker will be someone that you are all very familiar with, the board's Deputy Director, Steve Smith. Steve is going to provide updates on the progress the board has made on key projects. Welcome, Steve. Thank you for being here.
Thanks, Larissa. This is when you just keep your fingers crossed that the technology works. All right. Thanks again, Clarissa, and thank you, board members. Over the past several months, I'm sure that you've all heard about the regulatory agendas that have been adopted and the work that was put forth for the board. I thought today it would be useful to kind of give you an update on where we are with those, what's going on with the implementation, and some of the timelines associated with it. Specifically, I thought we'd talk about the medical portal, the drug formulary, medical treatment guidelines, expanded provider registration, and what we've got coming in the upcoming months that hasn't quite made it to the starting line quite yet. Starting with the medical portal, this is actually a screenshot of the new medical portal that'll be released later this month. It also doubles as an eye test, so if we want to take a little bit closer look, it's set up as 3 separate and distinct cards. There's one that kind of addresses what providers need to do. There's a card associated specifically with treatment, and then there's also a billing card. To look at them a little bit more closely, this is the medical provider card. The primary functions that providers will be doing here is, this is the gateway to training. We've set up a series of 11 to 12 new training sessions that new providers will need to take as part of becoming board authorized. We've also set up an electronic process that I'll talk a little bit more about later that providers will actually be able to do and make their request online instead of filling out paper, sending it, mailing it, hoping it gets there, etc. We've also put in place a process that providers, concurrent with the renewal of their SED, state ed license, also have to update their registration information with the board. You may remember we underwent an initiative about a year ago to update registration. We had about 40,000 authorized providers, and when we went through the re-registration process, we discovered that actually only about 10,000 of those providers were still doing workers' comp. So we needed to come up with a mechanism to keep our list more up to date. So this is the mechanism we've developed, so it'll be an ongoing updating of the registration. The treatment card is probably the one that providers will be using the most in the day-to-day providing of care to injured workers. There's a section for medical treatment guidelines. We'll talk more about medical treatment guidelines a little bit later, but they'll be able to access directly online the medical treatment guidelines. We're also going to be releasing a medical treatment guideline lookup tool where the providers will be able to enter in the condition that they've diagnosed, the procedure that they want to perform, and then be told whether or not it is in alignment with the medical treatment guidelines, whether it's recommended, not recommended, or conditional. They then will be able to click on a link that'll take them directly to the medical treatment guidelines so they can get more information. So it'll take some of the legwork that providers currently have to do to flip through the guidelines, try to find what they're looking for, figure out whether it's covered, etc. So we think that'll be a big improvement and a time saver for providers. There's also a section related to the new drug formulary. There's an overview providers will be able to access. There's also a lookup, so they'll be able to see what's on the formulary, and again, we'll talk about it a little bit later. And there's also a process for doing an online non-formulary drug prior authorization. The C4 auth and MG2 process are going to be upgraded in the coming months, but currently we'll have a link there that will just take them to the current process to help facilitate that. And one of the other things that's new is we'll also have a link directly to the DOH Department of Health iStop program for prescription monitoring that providers have to do, that they have to check prior to writing a controlled substance prescription. So this, we think, will just be a little added bonus for them to save some time to get directly to that iStop program. The billing section, the primary things here are the medical fee schedules, which will obviously be posted, and information for providers about what they want to do if they've got a disputed bill that they want to have addressed. Moving directly to the formulary, you'll probably recall in 2017 there was legislation that was passed that required the board to establish a drug formulary by December 31st of 2017. On December 28th of 2017, the board released a subject number with the first draft of the formulary, received a number of comments, submitted or released a second draft for public comment on October 17th of 2018, and adopted a final version on January 23rd of this year. The formulary was developed to be in line with the medical treatment guidelines, and it was based on a medication's effectiveness and appropriateness for the care of injured workers. It should be noted that the formulary does not apply to drugs that are administered in the hospital setting or in the physician's office. So the timeline for the implementation of the formulary, it was officially adopted May 21st of this year, became effective June 5th of this year, which means new prescriptions must comply with the formulary by December 5th of this year, just around the corner. And refill prescriptions need to be in compliance with the formulary by June 5th of next year. The formulary consists of 3 separate drug lists, uniquely labeled Phase A, Phase B, and perioperative drugs. The drugs listed on these can be prescribed in accordance with the following framework. Phase A drugs are those drugs that can be prescribed and dispensed within the first 30 days following an accident or injury, or when a carrier accepts a claim or the board establishes a claim, whichever occurs first. Phase A drugs can be prescribed for up to a 30-day supply unless there's a special consideration that's associated with the drug, and we'll talk more about those in a minute. Phase B drugs are those drugs that can be prescribed and dispensed after 30 days following an accident or injury, or less than 30 days after the injury if the carrier has accepted the claim or the board has established a claim. Drugs in the Phase B list can be prescribed for up to a 90-day supply, again, unless there's a special consideration that's been identified. Phase B drugs are used when a body part or illness has been accepted with or without liability or established. Drugs must be prescribed in accordance with the medical treatment guideline if there's one currently adopted for that particular body part. You'll also see when we take a look at the actual formulary that some drugs in Phase B are designated as second, which means they can be prescribed or dispensed after an unsuccessful trial of a first-line drug. And these are outlined in the specific medical treatment guidelines. There's also a perioperative drug list, and these are drugs that can be used during the perioperative period, which we've defined as 4 days before through 4 days following a surgery. I mentioned second-line drugs. These are drugs that can be prescribed after an unsuccessful trial of a first-line drug, again, in accordance with the medical treatment guidelines. I mentioned briefly special considerations. We currently have 3 special considerations. The first one is uniquely labeled Special Consideration Number 1. This consideration indicates that a drug cannot be prescribed for more than a 7-day supply. This is a one-time prescription only, not more than a 7-day supply. Can be prescribed during whichever phase of the formulary the injured worker is under. An example here would be a 7-day supply of opioids during a perioperative period. Special consideration number 2 are those drugs that can be prescribed for and dispensed for the prescribed course of therapy. Which basically means whatever the prescriber is writing the script for, they can be dispensed for. And the primary example here are antibiotics or other anti-infectives. Special consideration 3 indicates that only the short-acting form of the particular drug can be dispensed. And again, the primary example here are opioids and some of the other skeletal muscle relaxants. So what does the formulary look like? Well, this is an example of it, another eye test. It's divided into multiple sections. It's arranged by therapeutic category. The generic name of the drugs within the therapeutic category are then listed. If there are any special considerations, they're carried on the same line. It indicates whether the drug is covered under Phase A, Phase B, or during the perioperative period, and then it then lists the medical treatment guidelines. So you'll see that if the drug is consistent with the medical treatment guideline, there'll be a yes under the medical treatment guideline. If there's nothing there, the drug is not considered appropriate for use under that particular medical treatment guideline and would need a prior authorization. You'll also see, as I mentioned, some drugs are listed as second line, again, meaning they can only be used after an unsuccessful trial of a first-line drug. Should also be noted that certain OTCs are covered under the formulary, and these OTCs will be processed by the pharmacy and paid for by the carrier if they're written on a prescription. If you have a formulary, you have to have a prior authorization process, because as you know, there's exceptions to every rule. So when is a prior authorization needed? A prior authorization is needed when the drug is not listed on the formulary, when the prescriber wants to use a brand name drug, when a formulary generic is available for a combination product, unless the combination is specifically listed on the formulary. A prior authorization is needed for a brand name drug when a generic version of the same active ingredients is commercially available and on the formulary. A little bit confusing here, but an example of this is a product that is currently generically available in 5 milligram and 10 milligram strengths, but there is a brand name product for the 7.5 milligram, which is not generically available. So we've got generic 5, brand 7.5, generic 10. If the prescriber wanted to use the 7.5 milligram product, they'd have to get a prior authorization approved. And also, any compounded drug needs prior authorization. So to do a prior authorization, the medical provider would go back to the treatment card. They would click on prior authorization request, and given the fact that they have logged into the system and they've already looked up a case, the system knows a lot about them, so we think this is going to be a big time saver. So information about the injured worker is already pre-populated for the prescriber. The employer information is already on the form. Payer information is already identified from the system and populated into the form, and information about the provider, given the fact that they logged on with their credentials, is also loaded into the form. So then the provider just needs to attach clinical documentation justifying or rationalizing why this non-formulary drug is needed. This can be in the form of either free text, or they can include attachments. They would need to provide specific information about the non-formulary drug that they want to use, how they're prescribing it, quantity, strength, frequency, those types of things. And then they just hit the submit button. When they hit the submit button, based on the information that's in the form, it knows where to send it. So they no longer have to look on the website and figure out what the fax number is that it goes to, but oh wait, I was told to use a different fax number because the other one isn't working anymore, and in order the chair had been submitted and now it has to be rescinded. That all goes away. The carriers are responsible for keeping the information that drives the routing of this request up to date. So when the provider hits the system, it automatically goes to the level 1 reviewer that was indicated in the system. This can be the PBM, the pharmacy benefit manager, or whoever the carrier designates as their level 1 contact review. They have 4 days, and the system is keeping track, to approve, partially approve, or deny the request. If they don't act within that 4 days, depending on the drug, an order of the chair may automatically be generated, or the request may go to the medical director's office for further review. If they do act within the 4 days, the response will automatically go back to the provider. The provider will then decide whether or not, if it was approved, they'd go ahead and write the prescription, or if it was denied, they may decide to use a formulary agent, so that's a decision the prescriber needs to make. If they decide that they want to appeal that request, the prescriber has 10 days to make that determination. When they complete additional information on the form, basically refuting the reason the carrier denied it, they'll insert that information. They'll hit the submit button, and then the form will automatically go to the second level review. The second level review by regulation has to be the carrier's medical director. So it automatically goes to the carrier's medical director. They, again, have 4 days to either approve, partially approve, or deny. If they miss the 4-day window, again, an order of the chair requiring payment may be submitted, or it may go to the medical director's office for review. If they do respond within that 4-day window, the response automatically goes back to the prescriber. Again, they then have to decide whether or not they're going to write a prescription based on what the carrier said, or whether or not they're going to appeal it. It should be noted that at each level of this process, the person doing the review needs to provide justification for their response. So at level 1, if the carrier is denying it, they need to provide the clinical justification why they're denying it, in keeping with the reason the prescriber wants it. If the prescriber then wants to appeal it, they need to basically respond to why the carrier denied it with additional clinical information, and so on through the process. If the prescriber wants to appeal the level 2 denial or partial denial, they can do that by, again, providing additional clinical information. That review automatically goes to the medical director's office, where they'll review it and, again, respond to the prescriber to do the ultimate writing of the prescription. In relationship to medical treatment guidelines, as you know, we currently have 7 approved medical treatment guidelines. The process that we've used in the past has been, we've worked with the MAC, the Medical Advisory Committee. We've basically given them a blank sheet of paper, and they've been responsible for coming up with the medical treatment guidelines. In the middle of 2018, we contracted with the Reed Group, who is the caretaker, if you will, of the ACOM, the American College of Occupational and Environmental Medicine medical treatment guidelines. And instead of starting with a blank sheet of paper, we're starting with those ACOM guidelines. We supply those ACOM guidelines to the medical director's office, who reviews them and makes modifications to them, does some streamlining of them, reformats and makes them more usable for the provider. Those revised guidelines then go to the MAC. They review them, typically make additional modifications, and then they get distributed for public comment. We currently or recently released 4 medical treatment guidelines for public comment, specifically ankle and foot, elbow, hip and groin, and interstitial lung disease. So those are out for 60-day comment. And we're in the process of working on 4 additional, specifically asthma, hand, wrist, and forearm, PTSD, and eye disorders. You're aware that during the last legislative session, there was approval of an expanded provider bill, so we're in the process of implementing that as well. Currently, as you know, just physicians, chiros, podiatrists, and psychologists can treat injured workers. As of January 1st, 2020, we'll add to that nurse practitioners, PAs, OTs, PTs, and LCSWs. What they can do varies. As far as providing treatment, LCSWs, NPs, and PAs under supervision can provide direct treatment. Acupuncturists, occupational therapists, and physical therapists can provide treatment with a referral only. They can't provide direct self-referral care. The initial diagnosis and/or disability identification can be done by LCSWs and nurse practitioners. NPs and LCSWs can opine on ongoing disability, as can physician assistants. Permanency is limited to nurse practitioners and LCSWs, and none of the new provider types will be able to provide independent medical exams. We're expecting an onslaught, or I guess hoping for an onslaught of new providers that will be registering, so we're in the process of automating that process as well. As I mentioned, there's the 12 training modules that, depending on the type of provider that you are, will determine which of the 12 modules you have to take. And we have put in place an automated process for requesting authorization. So when the provider goes online, attests to the fact that they've done their education that was required, everybody but the physicians will submit an application directly to the board. Physicians submit the applications to the County Medical Society as well as the Osteopathic Medical Society. Those applications will also be routed directly to the board, simultaneous to going to the County Medical Society. The County Medical Society has 45 days to make a recommendation to the board. The board will obviously be reviewing those recommendations, those applications, and the board is ultimately responsible for providing the authorization and notifying the provider of the results of that review. Future things, we should have what I just mentioned mostly in place by January 1st, and Mary Beth isn't giving us a rest, so the next things that we're going to be looking for are the C4 auths and the MG2, as well as a prior authorization fee schedule for durable medical equipment. These items will be listed on the treatment card again of the medical portal, so this will be the way that the provider will be able to access those, and we're envisioning something very similar to what's done for the pharmacy prior authorization to work through those processes as well. So that's basically what we've been up to as far as implementation, and would open it up to any questions.
On your,
No, go ahead.
okay, on the level 2 review, you use the term, the carrier will send it to their medical director. Is it the director, or did we change the term carrier medical professional?
It is the medical director, because a medical professional could be a nurse, it could be anybody else. For the level 2 review, we are requiring that the carrier's physician do that. If the carrier doesn't have a physician, they can delegate it to a URAC, a utilization review, accredited committee entity for review. But in order to do that, they do have to submit a request to the chair to get approval to do it somewhere other than through their medical director.
On the prior authorization, kind of in line with this question, it goes to either an order of the chair or the medical director's office. What's the determining factor as to which goes where?
The drug type. If it falls within specific therapeutic categories, such as narcotics, benzodiazepines, we didn't want an automatic order of the chair for something like that. We wanted it reviewed by somebody for medical appropriateness, rather than just automatically approving it.
And I guess I have one other question. When the billings come in through the medical portal, we're going to see things completely differently in I think, eventually, the electronic case folder.
Yeah, the CMS 1500 project, which is a multi-phase project, we're about to implement phase 2. Testing has been completed with the trading partners, but what's going to happen there is the physician will submit to the carrier via a trading partner. So that's an electronic submission of the CMS 1500, which is the form that they use to bill any other kind of insurance. When the carrier receives it, they'll provide a response back or an acknowledgement back to the provider that they've received it. At that point, we'll also get a copy of it into our system as well. So they're not doing it through the medical portal, they're doing it through a trading partner, but we ultimately end up with a copy of it.
Okay, thanks.
At level 1 review, do you foresee the self-insureds and the carriers using PBMs more frequently?
Yeah, that's the expectation, and we've recently opened the system up for the carriers to start designating their level 1 and level 2 contacts, and that's primarily what we're seeing so far is they're going to be using PBMs for that, which makes sense.
Okay.
Okay, thank you very much.
Thank you so much, Steve.
Thank
I
you.
really appreciate it. Okay, last order of business. May I have a motion to adjourn the meeting?
Motion to adjourn.
Okay, all in favor? Aye. All opposed? I am also a yes. Meeting adjourned. Thank you, everyone.
Thank you.